We are going to do a very interesting topic today and have some great speakers. I am the webinar coordinator for SPSP and appreciate you all participating today. I want to thank Sedgwick Brand Protection, who is sponsoring this year's webinar series as they did last year. And just a couple of administrative things, little promo things before I introduce the subject and our speakers. On May 15th, we have the next webinar on the CPSC's involvement in standards development. June 18, we've got Rod Freeman and his folks talking about an update on the EU and UK product safety and product liability regulations, and a lot of things going on there. And then we'll take a little break over the summer and start again in late August. One last little promo thing. We are inviting people to become SPSP members. It's a very modest fee. We're trying to provide some benefits as a result of the membership, but it's probably more importantly will help us expand the offerings that we have in the future, offering more programs and more benefits to members. So it's a little bit of an investment, I guess, for the membership in helping SPSP expand in the future. Okay, so let me introduce our speakers. And I didn't think too much about this, but I have two Johns as speakers, so hopefully I won't mix them up during this program. So I may say John D, John K, if you don't mind, just make sure I don't mess them up. But anyway, our first speaker is John Dornick. John is a partner at the Siegel Brill law firm in Minneapolis. John is one of the most prominent, respected, successful plaintiffs lawyers in Minnesota and probably elsewhere. He is I can say this tongue in cheek, John Dornick. Unlike most plaintiffs lawyers, he's a great guy, a great lawyer. He's fun to work with, even when you're giving him a lot of money. And he's very active in the Bar Association in Minnesota, both locally and on the state level. So I think he's will be a very good contributor to this subject on the involvement of product safety in product liability litigation. Next, John Cuppins. John is in Columbia, South Carolina at the Nelson Mullins Law Firm. John is a well-respected, a very, very experienced trial lawyer and works in the safety area and regulatory counseling. And John is formerly the president of the largest defense lawyers organization in America, called the Defense Research Institute. So he is very experienced and in particular very knowledgeable about safety issues and their involvement in litigation. So I'm going to stop sharing my screen just because we don't have really a whole lot of slides to present on that. So let me just introduce the topic. I spent many years as an in-house lawyer managing the defense of litigation, and after that have been a counselor, but also have been involved in litigation, mostly as an expert witness. So I have lots of experience with product safety as it relates to product liability litigation. And in thinking about this topic, and one of the reasons I thought it was useful to do, is that I can think of so many things that my clients have done right or wrong in the product safety area that have helped or hindered our defense. Now, our goal as product safety professionals is to prevent an accident from happening. That's our main goal in life, and that's what we want to do. But it is not, we shouldn't be ashamed to also try to, as we're making safe products, to provide products that can be defended later. And we've got a lot of people to defend it against, possibly the government, a plaintiff's lawyer, a jury, a judge, our shareholders. So there are a lot of reasons why we need to really think about this topic we're going to talk about today, and that is how can we defend the adequacy of our efforts as we design and manufacture and sell products. Now, the main concept, the main thrust of a product liability case, very simply, is could we do more and should we have done more? And we're not going to get into the niceties of the law, whether it's strict liability or negligence and things like that. But just could you have done a better job, and would that have prevented the accident from happening? And when you think about it that way, you say, well, of course, we can always do more. So the question is always, as we think about safety, is, well, where do you draw the line? When is enough enough? When is your product safe enough? There's no product that's absolutely safe, but when is it safe enough? Now, in litigation, you as product safety professionals will be, I'll say targets, but at least you'll be relevant witnesses or participants in the defense of the litigation, either through answering interrogatories, which are written questions to the manufacturer that have to be responded to, or providing documents, or be deposed as a witness in the case. And then ultimately, if there is a trial, may have to be a witness during trial. So those are the main ways that you'd be involved. Now, I did have an experience many, many years ago as an in-house lawyer where the chief engineer of the division whose product was being sued was also sued. So the engineer was sued in the lawsuit. He was a named defendant. And that doesn't happen very often. And the company is going to defend that individual defendant. But that made him more relevant in the case and more of a target for the actions that he was involved in. Another situation I'm familiar with, manufacturer makes a product. They consider different designs of that product, design A, B, and C. They select design A for the final product. And they get rid of all the documents on the other designs that they considered but rejected. So at the time of the lawsuit, then the plaintiff's attorney is asking about other designs. Did they consider other designs? And we had no documentation on those. And that proved to be very difficult, both with the judge and the jury, because it didn't look like we cared about safety, because we destroyed documents related to the safety that we had tried to build into the product. Another case that I was involved in that we lost. We had testimony that there was safety testing that we did during the development of that product, but we couldn't find the documentation to show what the testing was and to prove that we did it. Lost the case and interviewed the jury afterwards, and they basically didn't think we cared that much about safety because we didn't have documents to prove what we did. So when we're doing these things, we want to do our best, do what we think is appropriate, document it accurately, truthfully, clearly, so that you or someone else in the future might be able to testify as to what the company did. And you want to be able to show that you're a good company that did all that you thought was appropriate. Now, going back to what I originally said, and that is that the plaintiff's attorney is always going to try to say, whatever you did, you should have done something different. So you can't agonize over that. They're always going to argue that. I would say good plaintiff's lawyers like John Dornick are going to consider whether to even proceed against a company that did a good job, even though their client was hurt with that particular product. I'll say this, maybe not all plaintiffs lawyers, but plaintiffs lawyers are looking for easy cases. Now they want to go after companies that didn't do a very good job. So if you did a good job, but you could still have done better, the case might not be brought, the demand might be less, you might actually win the case possibly. So there's a lot of things that go into it. So you can't agonize over the concept that whatever we do, we're going to be criticized, and some plaintiff's expert will come in and say we should have done better. So with that in mind, I thought was an interesting topic to talk about what real live trial lawyers, which is not me, think about as they're developing a case and going through the process of the discovery process to try to determine if the cases should proceed or not. So with that said, let me turn it over to John Dornick, uh, who will regale us with stories about the plaintiff side of this issue.
Well, hello. Thank you, Ken. And it's great to be here to speak with all of you. You've got really important jobs. And I say that as a lawyer, but also as a consumer. I really look up to folks that do what you do, and it's very important. So I just wanted to say that. And I'm fortunate to be here with Ken and John, two very knowledgeable and experienced fellows, and nice people on top of that. So thank you for that as well. As Ken had said, I only do the plaintiff's side of cases. A lot of my practice is products liability. I actually have taught the product liability class at the University of Minnesota Law School up here where I live. I taught that for years with Ken Ross, as a matter of fact, until he moved from here. And then I taught it on my own for quite a while. I've been doing this for over 35 years, and I've handled product liability cases, aircraft, automobiles, industrial products, products for the home, recreational vehicles, so clothing, all different types of cases like that. And what I look for when I'm taking a case is typically, the damages have to be significant. And so I guess, from my side, and you folks definitely don't need advice from me, but, obviously I think the goal is to do whatever possible to prevent the catastrophic injuries. Because those are the ones that typically turn into a product liability case. If, somebody, broke a little finger, a lawyer like me is probably not going to take that case because the effort involved in pursuing a product liability case and the expense involved in hiring engineers and other experts like that doesn't warrant pursuing a case limited like that. And obviously, you look for a solid theory, not just, someone got injured while using a product, but basically, was there a defect in the product that caused that injury? And then we can get into, how a product safety might have been involved in making that defect foreseeable or preventable or whatever. But, we have to make sure that the product caused an injury and that it most likely was, at least can be characterized as a defect in that product. So those are some of the things that I evaluate before I would even take a case. And was the injured person engaging in a foreseeable use or a foreseeable misuse of the product? And I'm sure you folks all know that, but there are cases, many cases, where a consumer was misusing a product, and there still is a case because, we all know it was a foreseeable misuse, foreseeable maybe for sure to the manufacturer. At least someone like I could argue that. So was it foreseeable, or could we argue that it was? So those, I think, are kind of generally speaking some of the factors that I look at to evaluate whether or not a case should be pursued. And kind of to get at, at least what I think is what Ken wants the topic to be: how does product safety play out in product liability litigation, at least from my side of it? I look, are there industry standards involved in with that particular product? That's always kind of an initial thing I will look at. And does it appear as though those industry standards were followed? Hardness of metal and maybe a metal failure case. As far as flammability of clothing in that kind of a case. Are there certain size component parts that ought to have been installed in a manufactured product? Did they follow those standards? So, that kind of lays out what we call a standard of care. Did the manufacturer follow those standards? Because if they didn't, then, right there could for sure be an argument that someone that does what I do can make, that they didn't follow the applicable standard of care in this industry, as set out in these standards, right? So I'm sure you folks deal with standards all the time, but that's kind of how we might use those from our side of it.
Can I interrupt, John?
Yes.
But you could also argue that the company should have exceeded standards, and you would go get an expert. So I want to make sure they know that, you are trying to comply with standards, but you might need to exceed standards, which is kind of a big unknown as to when you did. But you would be looking at that too.
Yes, I agree with that. Particularly if in that industry, your typical manufacturer does exceed those standards. So we've got precedent of, we're not just saying this particular manufacturer should have exceeded the standards, although we might argue that anyway, if I get a good knowledgeable expert that does a good job helping me with that theory. But if other competitors in that industry are routinely exceeding standards, then now we've kind of have a higher standard even that's been developed by the industry itself. Is that
Yeah,
kind of
that's
that?
right. And the same thing would apply that if there's no government standard or voluntary standard, then the question could be, and the term we use is state of the art, meaning that what are your competitors do? So you always want to look at what your competitors doing from a safety standpoint to determine if you should be doing better than you're doing.
Exactly. I agree with that. If state of the art is to produce a product that's safer than the product you're producing, then that's evidence we can use. If you meet the higher standard or the standard of the art, then it's harder. Then someone like I have to argue that the standard should even be higher than that. And while that argument is possible with the right experts, it's a much more difficult road to hoe. So try to keep up with your competitors when it comes to safety of a product, for sure. I agree with that, Ken, wholeheartedly. When I'm trying to kind of get at what happened with the manufacturer and what took place behind the closed doors, I often will want to depose the manager of product safety to get at what tests did you run, or what standards did you apply. What were the results of some of the tests? Did you do hazard testing? What were some of those results? Maybe at time I have deposed members of safety committees to try to find out, kind of the marching orders from them, or what they did or didn't do in a particular case. Oftentimes I'll want to try to find out and depose maybe the engineer who designed a product or was the head of a team that designed a product. If that person isn't, we can't figure out who that particular person is, maybe the head of engineering. And then we often do what are called Rule 30b-6 depositions. And I don't know how familiar you folks might be with some of those, but named after the rule of civil procedure, where I send something to the manufacturer, say, I want your representative that can tell me about product safety, product testing, design, and warnings, or something like that. And then the company, the manufacturer, has to designate somebody that on behalf of the company can answer those questions for me. And if the person they choose maybe isn't the expert on all of those topics, then the manufacturer has to educate that person so that when they do appear before me, they're educated and can answer on behalf of the company. John K., I'm sure you have to defend depositions like that all the time, and those can be quite
absolutely.
effective.
They certainly can. A designated representative for a 30b-6 deposition speaks for the company, and so it carries great weight.
Yeah. And well, anyway, and so that is really an effective tool. So if anybody from your company knocks on your door and says, we want you to be our 30b-6 representative, you've got a lot of homework ahead of you, probably. And how does product safety work in these cases? Well, sometimes I find out when I'm looking into a case that there wasn't any real product safety employed at all. And those probably are the easiest cases, because the manufacturer can't tell me that it wasn't foreseeable that a defect would have happened, because they never tested for it. How would they know? right? So if I get an expert that says that hazard or that defect that caused that injury was foreseeable, it's going to be difficult for the company to defend that argument when they never did the testing at all. So other than it's obviously a great idea to do as much testing as you can to produce a safe product, as far as litigation is concerned, it's also the right thing to do as well, because then at least you can defend on foreseeability. You know, we did the testing, we never had that result. You know, how could we have ever foreseen this result? So, you know, that does happen. And, but more often than not, you know, I find out there was some product safety analysis done. So then I want to dive into, you know, was it hazard safety analysis, and what did you do? What testing did you do? Who was involved in the testing? Were they engineers, product safety personnel, all of the above? And Ken had mentioned reasonable alternative designs. Were there other designs used? And if so, why did you use this end design over the other potential designs that you were looking at? And, you know, give us the analysis and the documents that went with this decision, so we can do our own analysis. Like Ken mentioned in his scenario, if those documents are now missing, it's easy for someone like me to argue to a court that it's suspect that the conclusions reached by the product safety folks were that this product was the best, when we have no analysis to look at and to analyze ourselves. So like Ken said, we can argue, you know, we have no evidence of that you chose this product was the safest, therefore we don't think you did. We don't know what made you end up with this product, but we have no evidence that it was the safest design that you had available. Oftentimes, I'll have experts will come forward with a reasonable alternative design and say, this is a better design, we believe. And then, of course, that's up to you folks and your lawyers to argue that we are wrong. Some of the other things then, if there is a defect and the testimony is we were aware of it, but it couldn't be designed out, right? And that happens all the time. I'm sure you folks run into that all the time. Then that's when, okay, this defect can't be designed out. So how were the warnings, right? If there weren't any warnings regarding a defect that you knew couldn't be designed out, that's a problem for defendants. Obviously, most of the time there typically are warnings if that's the case. And then we look at the warnings themselves, the language employed. Maybe a human factors expert who will try to determine is that the right language for that particular warning? The placement of the warnings, was it put in a conspicuous enough place? Was it buried on page 74 of a manual, or was it placed somewhere where it could be seen and heeded? And were the warnings designed to get to the end user, right? Not the retailer, not the installer necessarily, but the end user, the consumer like me, who can be like me, be unsophisticated. You know, I probably need a pretty explicit warning designed for somebody like me, for me to heed it, right? Not a sophisticated intermediary, but the end user. What were the warnings designed for end users and to be delivered in a effective way to that end user? And I know the time allotted to me is kind of coming to an end, so I'll just kind of skip ahead. Strategy. I prefer, if I have time on statute of limitations, to pursue strict liability and maybe warning claims rather than negligence initially. And Ken and I had this discussion that opens the door for due care to come in through the defense. If during discovery I find out good evidence of negligence, I might try to amend the case because now I've got some good evidence of negligence. But if I have a defective product that caused the injury, I've got my strict liability theory that I ought to be able to pursue. So I might not allege negligence until I maybe come across some evidence during discovery. And the last thing I'll say is, if you folks do the best job you can and you're thorough and looking to make your product as safe as you can, even if you can't make it completely safe, I think the lawyers that do what I do, that know what they're doing and do the best job, oftentimes won't pursue a case or will dismiss a case when they're doing discovery and they find out that you folks did the best job you could, and it's more bad luck than bad manufacturing or bad safety practices. A lot of times those cases will go away. There we go.
Can I ask you one quick question, John? You mentioned
Absolutely.
reasonably foreseeable use and misuse, which we all hear about, and we don't know what the heck that means because we don't know how a jury is going to react to that kind of stuff. Assuming that the manufacturer identified reasonably foreseeable misuse and they warned against it, and the plaintiff ignored the warning and did it anyway and got hurt. How would you look at that situation?
Well, if it played out exactly as you just said, I probably wouldn't take the case, right? But we'd have to, if the injury was bad enough, it warranted looking at it more thoroughly. We'd get into the language of the warning. Did it really adequately warn a person in the position of this injured plaintiff? If it's all in English and the person, I mean, there's an example, and the person was not English speaking, should have been a different type of warning. Things like that. Ken, were you looking for anything else other than that, or?
No, that's the answer I would expect you have.
Yeah.
And then there's actually a famous case where the warning said that that if they did something that it would be toxic, and the people died, and they lost the manufacturer lost the case because the jury believed that the word toxic was unclear.
Yeah.
So you can warn about not misusing a product in a certain way, but you might not do it clearly enough or adequately enough, and so there's still an argument that could be made.
Yep, absolutely.
Okay, let's turn over to John Kay, and then we'll have time for more questions at the end. Thank you.
Thank you, Ken. Hello, everybody. It's great to be able to work with John and Ken on this. And as Ken said, I've been practicing for over 34 years and have always defended manufacturers in product liability litigation. But the unusual thing about my practice is I also counsel on regulatory compliance and risk prevention type issues. So I guess the first thing I want to say is that we're going to talk about things that a company would do, should do, to make a reasonably safe product. And I always tell my clients, and I would say to you, that should be your primary motivation here, to make a reasonably safe product, to do the things that competent employees of a manufacturing company would do to manufacture a safe product. And the touchstone of that in product liability law is to oversimplify the concept of reasonableness, and so in a lot of ways, can you show anybody who's asking that the steps you took were reasonable? There are other benefits of doing these things. One of them is that if you're sued, and if you're a product manufacturer in the United States of America, you will be sued. It helps you defend that lawsuit, which would be, presented to a jury in product liability cases. The other way that doing these right things can help you is that they can help you achieve regulatory compliance. And I think you all know about the CPSC, which has jurisdiction over consumer products, but there's the Federal Trade Commission, which has jurisdiction over truth in advertising. And so that's something that you need to be aware of. They also have regulations regarding when you can say made in America and when you can't. And then for drug products, there's the FDA. For cars, there's NHTSA, et cetera. And I'm going to try not to talk about too many, legal concepts that are, not of interest to you. But I do want to say that and I think John touched on this, there are usually 3 different legal causes of action that are brought against a manufacturer in a product liability lawsuit: strict liability, breach of warranty, and negligence. And they all have 3 common elements, and then negligence has an additional element. The 3 common elements are, is the product defective and unreasonably dangerous? And we say defect in South Carolina, but there you look at, like, have you reasonably assessed what the risks are associated with the use of your product? And have you weighed that against the utility of the product? In other words, a knife has to be sharp to do its job. So you can't completely eliminate that aspect of the product. But so the utility plays a role. Some courts, some states look at, instead of risk utility, consumer expectations. Does this meet the reasonable expectations of a consumer in terms of safety? So number 1, is there a defect? Number 2, causation. This is a complicated concept even to lawyers, but the question there is, did the product defect cause the damages? And they look at 2 different kinds of causation in product liability litigation. They look at cause in fact, which is basically, but for running the red light, the accident wouldn't have happened. But they also look at what's called proximate cause, or some people call it legal cause. And what that means is, and again, there's a reasonableness element to this, but was the action, the making of a defective product, designing of a defective product, was that close enough in the chain of events for the injury for it to be, fair to blame this injury on this defect? And then, of course, the damages, which could be personal injury, could be property damage, and those are what's called compensatory damages or actual damages. There's another concept called punitive damages, which maybe we can talk about if we have time, but negligence has the additional element of, John called it due care, I call it reasonableness. And then, so it looks at the conduct of the manufacturer. The other 2 don't look at the conduct. Negligence looks also at the conduct. And so the plaintiff has the burden of proving all of these things in a lawsuit by what's called the preponderance of the evidence standard, which just means more likely than not, 51%. And a product can be defective in a number of ways. There can be a design defect. So, say, for example, there was just a better way to design this, or guards could have been added, or cutoff switches, or anything like that would have made the product safer. There can be a defect in manufacturing, which is basically not following the design specifications in the manufacture of the product. There could be an assembly problem. There could be bound up in manufacturing, could also be like, you didn't do adequate testing. And then there's the concept of warnings. So, a lot of people say that there's a product safety hierarchy, that you should try to design a safe product. If you can't, you should guard. And if you can't, then you should put warnings on it. And so you can have a product that, the main focus of the litigation is the warnings were inadequate. And John talked about that. Finally, in some states, you don't have a duty to recall a product under the law, although the CPSC might say something about it. But if you do undertake to do a recall, then you have to do that reasonably. And so there can be, in some states, you can be sued for negligent failure to recall in a reasonable way, not getting the word out adequately enough, those kinds of things. So against that backdrop, when I am asked to defend a lawsuit, the first thing I think about, and the thing that I try to keep front of mind the whole time, is what is our story here? So that includes talking about what did the company do? What did the plaintiff do? And were there any third parties that were involved who bear some responsibility for what happened? And a very, very common scenario that's an example of third party fault is you make a product and it's got guards on it and you sell it to this company, and then somebody at the company decides that the guards are in the way or they're slowing things down, and they remove the guards, and that's why the injury happened. So in that situation, the manufacturer would not be responsible. And the third party acts kind of, I guess, break the chain of causation, if you will. They kind of interrupt what you did versus what happened. And of course, what the plaintiff did, it includes, whether the plaintiff was, used the product according to the warnings and instructions and generally was reasonable in her actions. But the main thing we want to talk about here is what the company did. So how do we tell our story to a jury? Part of that hopefully would include an explanation of what the company did to evaluate the hazards associated with the products and to account for those to ensure the product is reasonably safe. And so there are a lot of different things that a company could do in that regard. Perhaps you're familiar with the failure mode and effects analysis, and there are all kinds of different terms and matrices used, but the common idea is to have knowledgeable people, engineers and other knowledgeable people, try to understand what all the potential hazards are with the use of that product, evaluate which ones are most likely, evaluate which ones are most severe, and then take steps to try and eliminate the likely and severe hazards. And again, if you can't design it out, you guard. If you can't do that, you warn. So other things you could do, and I think, are expected to do, and everybody does, are, do you do testing? Do you do development testing? Do you do prototype testing? Do you do post-production testing? Do you do certification testing? All of these things help you tell your story. Did you have a third party evaluate it? Sometimes when there's testing to be done, third parties are engaged, and they can be helpful to explain, what was done and why, just to kind of, add another voice to explain and defend your actions. I guess I should say that in a lawsuit, the lawyers are allowed to send each other, in addition to depositions like John talked about, they can send you a written questions to be answered in writing, which are called interrogatories. They can send you requests for production of documents, and those will always include, tell us, what the documents are that show that you did these things that we expect a reasonable company to do, the things that I was just talking about. And even if negligence is not part of your case, I kind of feel like all these things are still relevant to whether you did a safe design, okay? Because how else do you explain and defend that your design was safe other than showing all the steps you did and presenting why those were reasonable? And again, I'm going to harp on this. Did you act reasonably is kind of always the touchstone. So when you're talking about how do we tell our story and what are the facts that allow us to put the story together, then you say, who can tell that story? And so that's an important part of that, is to have somebody from the company or more than one person from the company. In an ideal world, that person would have been involved in the design. That person can speak to the steps taken by the company to evaluate the hazards and safely design the product. Why the warnings that were used, why the labels that were put on the product were put there, and what they say. And that person needs to be credible. It can't you can't be credible speaking on these issues if you're not informed, if you weren't, if that's not part of your job responsibility to have that knowledge. And product safety committee is something that a lot of companies have. Sometimes that's a separate group unto itself. Sometimes it's integrated with other aspects of the company. But John said he was usually asked to depose the manager of product safety. That could often be the person who's the head of a product safety committee, if you have one. I generally think it's a good idea to have one for a number of reasons. They can help you kind of monitor what's going on with your products, what kind of inputs you're getting internally and externally about the safety of your products, and avoid siloing of information by talking together about what they're seeing to see if that helps them spot any trends that require corrective action. So a big part of this is who can tell that story for us? Who's going to be our witness? And that could be you all. And then finally, what evidence can we use to tell that story? So we know what the story is now. We know who our witnesses are, but what's the evidence? What's the proof? And so that's documents, testing documents, design drawings, other communications, and anything that kind of relates to the steps you took to ensure that you designed and made a safe product. An interesting thing there is that so for both the witnesses and the documents, it's important that those things are available to me for me to be able to fully defend the lawsuit. And so in companies, people don't always stay there forever. Sometimes they move on to some other job, or sometimes they retire. And so that's an issue that you have to deal with. And that if the witness who was involved at the time is no longer with the company, then it really becomes critical to have documents that somebody else can review to try and tell the story in a credible way. And so document retention is an important issue. Most companies have document retention policies because you just can't keep Raiders of the Lost Ark warehouse full of every document forever. But you need to pay attention to whether there are documents that need to be retained longer than the policy says, because they are important to your defense. That's not to say that you can't defend cases without that information. It's just much harder. There are situations I've had where a product was designed and made, 40 years before the accident. And then under those situations, people can understand why the people are no longer with the company and why all the documents that existed are no longer available. But that does just make it harder for the defense. Outside experts can help. But as I said, the story is much more credible when we can have somebody from the company show what was done. But outside experts could comment on the safety of the design compared to state of the art, compared to what others are doing, and generally, kind of put a stamp of approval on the design as being reasonably safe. And then there are also experts on warnings. We talked about standards. There are all kinds of standards about issues related to product design and manufacturing. There are also standards about warnings. And they talk about when to use the word warning versus danger, and what colors to use if you use color, and all kinds of other things, And as John talked about, I've always thought on the defense side, and I would always advise my clients, at a minimum, you should try to comply with the applicable industry standards. And the reason for that is because it enhances your ability to defend your conduct. Because, this is kind of the gold standard, if you will. Now, a plaintiff would argue that it's the minimum and more should have been done. And I think sometimes that's true. And sometimes a company needs to look at whether they should do more than comply with the standard. I talked about the product safety committee, And so I'm going to segue now a little bit into a couple of other issues and then wrap up. There are other reasons to have a product safety committee. The CPSC suggests to companies that they have a compliance plan, and that plan includes several key elements: whistleblower protection, C-suite involvement, document retention. But having a product safety committee to, evaluate hazards, share information across different parts of the company, and keep an eye on whether something needs to be reported to the CPSC or whether a recall needs to occur. I think that's super important. And if you don't have that, then it makes it harder to defend a lawsuit, and it makes it harder to convince a regulator that what you did was reasonable. And you don't want to mess with the CPSC, because if they feel like you haven't done what you were supposed to do, or you didn't have your enough organization in your company to report things to them in a timely manner, then they can come after you for a civil penalty, and those are usually in the multiple millions of dollars. And then the last thing I want to talk about is the concept of privilege. Attorney-client communications are privileged. So, like if I were talking to you and we were talking about how to defend a lawsuit, privilege means the other side can't have access to that information. But these privileges are narrower than I think most people think. If I'm communicating with you about, in the process of trying to give legal advice to the company, then that's privileged. If an in-house lawyer is communicating with you to try and give legal advice to his client, the company, then that's maybe privileged. But it's harder because an in-house lawyer wears a business hat and a legal hat. And so you'd have to be able to show that this was a legal communication. And a lot of people think if you just copy a lawyer on an email, that means it's privileged. That's not true. So you need to be careful about that. And in that regard, the design work we've talked about, hazards analysis, testing, emails, internal memos, instant messaging, all those things are probably not going to be privileged, would have to be produced in a lawsuit, and would probably have to share those with the CPSC. Also, just another thing is that information you provide to the CPSC is not privileged. And so if you do provide information to the CPSC to justify your actions to the regulator, then you have to disclose those in a lawsuit if you get the right question. So a lot of things to think about there. And the last thing I'll say is, on the topic of privilege, that sometimes when something happens and you're trying to assess whether there's a product safety issue that needs to be reported or needs corrective action, you need to do some investigation. And if I'm doing the investigation and I'm trying to get help from outside engineers to help me evaluate that issue, then I think that's my work product, and that's privileged. But that has to be handled very carefully. And I've had a lot of situations where companies learned of a few incidents, decided to do a bunch of internal testing without talking to me first, and created more problems for themselves by doing testing that kind of, made the problem seem even worse than they thought it was. So I'll stop right there. Thank you, Ken.
Okay, let me clarify one point, or maybe accentuate it, that even if an in-house lawyer or an outside lawyer prepares the documentation that you provide to the CPSC, it's not privileged. So the fact that it goes outside the company. So usually attorney-client privilege documents are going to be, within the company, whether it's an inside lawyer or an outside lawyer. Secondly, the product safety committee, even if a lawyer is on the committee, and I was on the committee of my company on the product safety committee, on several product safety committees, the fact that I'm a member of it, even if I'm taking the minutes, doesn't make the minutes privileged. Because it's not really a legal activity, although I could be providing legal advice. Now, if I sent an email to the head of product safety with legal advice on what design they should select, that could be privileged. But generally speaking, the operation of the product safety effort shouldn't fall under privilege, and particularly the CPSC activities. So if you're doing risk assessment and you're evaluating risks, and identifying risks that you can design out and those you warned about and those that you can't do anything about. That all is all privileged, and John Dornick is going to have a lot of fun asking you about why you sold a product that had demonstrably certain levels of risk remaining that could not be dealt with, and why did you think that was reasonable? So unfortunately, and we had an earlier webinar, and I think John Cuppins, you were actually on that one on documentation. That you don't know if a document's going to be helpful or harmful until you get to a lawsuit, and John Dornick starts asking you about it. So you want to document your safety processes. I think on balance, it is much better to do that, to show that you had a safety program, that you were a responsible, ethical, moral company that tried to do the best. It doesn't mean you're always going to win, but it means you can at least not get the John Dornicks of the world so excited that they want to go after punitive damages. But doesn't mean they can't still allege that you should have done better. And every time John Cuppins uses the word reasonable, what that means is the jury gets to decide. We don't decide. The judge doesn't decide. The jury gets to decide whether you were reasonable or not, or whether you should have done more. So it's, I think there are a lot of things, and we're trying to teach this stuff in these webinars, a lot of things that should make you feel like, okay, I did enough. I've documented it correctly. If somebody gets hurt and we get sued, I got something to talk about, but that's not a guarantee that this is going to go away or we're going to win. And certainly John Dornick said, in certain instances, if the company has a good safety program, he may not even bring the lawsuit. Well, you wouldn't even know about that. You may not even know about the accident. So it's kind of hard to tell, the CFO of your company, we ought to spend all this money on product safety, when the CFO wants to know how much money you're going to save by having this safety program. You just don't know. You can't prove a negative, and you can't prove how many accidents you're going to prevent. Before we go, there's one question that came up. Let me answer it, and then we'll see what else we want to talk about. Concerns recalls. If you do a recall in conjunction with the CPSC, and of course the CPSC approves that recall, does that protect you against later somehow a finding by a jury that you were negligent? Well, it doesn't protect you. I serve as an expert witness in recall adequacy cases, and certainly that's our argument. Our argument is, well, we went to the experts of the CPSC. We worked with them. They told us what they thought we should do. We did it. And the fact that this person got hurt, is unfortunate, but we did what they told us to do. Now, similar, and we haven't really focused too much on post-sale, although John Dornick, you could jump in on that. The fact that somebody got hurt and there was a recall is a really good fact for the plaintiff's attorneys. And so could you have done more? You can always do more in a recall. And unless it's 100% effective, in which case you wouldn't have an accident, you could do more. So they can always allege. Now, and how a jury will react to it is hard to tell. But somebody actually got hurt and you actually did a recall. So you want to argue that you did comply with the CPSC, but as we all know, the effectiveness rates on recalls with CPSC are in very low numbers. So you got a lot of products out there that could hurt people that you cannot get the consumer to return. So how do you defend the adequacy of your recall is is a big issue that you really need to consider. John Dornick, how do you deal with cases when there's been a recall? How do you go get do you get an expert to testify on that, or how would you deal with that kind of a case?
Yeah, I think the short answer is yes, you'd get an expert to do, was it a reasonable recall or not? I always, when I am looking at a product case and I find out there was a recall, I always think, boy, my chances in this case are much better. And it's kind of funny because, the company's trying to do the right thing now, right, by doing the recall, unless of course they had to be forced to do it, I guess. But and the first thought in my mind is, well, it's the case is better because of that. And obviously now we know there's a defect of some sort, right? So I still have to prove causation, like John discussed, proximate cause and all that, which isn't a given just because there was a recall, but at least product defect is pretty good. But I would get an expert then to talk about whether the recall was reasonable. If I'm representing somebody who's didn't return a product in which there was a recall, right? Then we have to get into that. I think that answers your question. I hope it does anyway.
Well, yeah, on that point, so if your client received the recall notice and ignored it and then got hurt, would you even take that case?
Probably not. Again, you want to look at the adequacy. If the damages are big enough and warrant taking the time, you want to look at the adequacy of the notice, but probably not.
Yeah, and
Yeah,
for the recall. Go ahead, John.
For the defense side, that's a good situation to be in if you've directly gotten information to the person about don't use this, here's the problem, and they use it anyway. That's a pretty good situation. On Stephanie's question, I just want to say there is a distinction between like who gets to decide whether you need to recall something and whether once you do it, you did it negligently or not. It's CPSC is the entity that gets to decide whether you should have reported something to it, whether a recall needs to be done. And, I would argue in the lawsuit that the plaintiff shouldn't be able to offer experts to opine that there should have been reporting or there should have been a recall, because that's up to the CPSC to decide, and that kind of is a preempts what the court or jury could decide. But as I said earlier, if you decide to do a recall, then you have to do it in a reasonable way. And like I had a case where a recall was done, and when you do a recall with the CPSC, they issue a press release and you put it on your website. But the best way to get notification to somebody is direct notice. Send them an email or send them a letter. And in my case, they had the plaintiff's name and contact information, but they didn't send him anything directly. And so that was what they focused on in our lawsuit.
Okay. Let's see. One other thing that in talking about the different kind of lawsuits, one thing we didn't mention are class action lawsuits, which even if you've got minor injuries, and John Dornick, I don't think you do class actions, but maybe you do. But
I do not. Or mass torts, you mean mass torts, class action kind of thing?
Right. Well, where you have a bunch of minor injuries or economic loss because the product is not working the way it should, the same theories are involved, although warranty maybe is a little bit more important. But it is possible, even if the product doesn't work the way it did, it's not, you lose economic value in the product, or you have a bunch of minor injuries which wouldn't justify John Dornick getting involved in the case, you could still be sued. And the adequacy of your safety is still relevant, even if the injuries or damage are fairly minor. So class actions, we see a lot of class actions are still being filed. And we're dealing with safety and the first committee I was on was called Product Integrity Committee because it was both safety, but also reliability and everything involving the product. So, we're trying to avoid product problems, dissatisfied customers, injury, damage, economic loss, all kinds of things. So that maybe is even a little broader than just the Product Safety Committee, but they could still all be part of a product liability lawsuit if it is brought. Well, okay, we've gotten to the end of the hour. see, there's one question left, which
You want to try and answer this private label question?
yeah,
Tim?
Private labelers, unless you want to,
Yeah,
go ahead. Just
sure,
one
I'll
more
give it a
question.
shot and then you can clean up.
Go ahead.
I mean, CPSC views private labelers as having kind of the same obligations as a manufacturer. And in litigation, if your name is on it, then you're going to have to, be able to defend your actions. And that could include, well, we sent the design specifications to, this manufacturer in China, which is often the case, and they're the ones that are responsible. But there are a lot of hurdles there, a lot of obstacles, because you can still be sued, you can still be the recipient of a CPSC inquiry as a private labeler, and then it's up to you to either pull the manufacturer in and have the plaintiff or the CPSC focus on the contract manufacturer, which is often challenging because they're not always within the jurisdiction of the courts or the CPSC, or show that you asked for and received from the manufacturer all the things that a reasonable company would ask them to show as evidence that they were complying with standards and using safe practices to make the product.
Okay, well, great. Well, we're a couple minutes over. I appreciate you sticking around. Thank you, John. Thank you, John. Appreciate it. Hopefully you found this useful. Again, we appreciate you participating in the SBSB webinars. Hope you we do post the video of the webinar so other people at your company can look at this. We'll post a couple of other things, some articles that relate to this topic. So you'll have some more material to take a look at. We appreciate you today and hope you participate in future webinars on behalf of Sedgwick Brand Protection that has sponsored today's program. We thank them and thank you all and have a good day.
Thank you.
Thanks, John.
Thanks.
Thank you, everybody.
Bye-bye.